Yeah, I hear you.
Ready?
You ready? All right. Is everything on, Jason?
Yes, sir.
Go ahead and call the meeting to order. Start with a roll call, please.
Brian Crawford.
Here.
Robert Knapp,
Here.
Monty Montalvo,
Here.
Chris Simeon,
Here.
Jared Ricky,
Here.
Erica Dorsey. Here. Lenore Feeney.
Here.
And Jason Henneman.
Here.
Want to advise the public as to our new person?
Yes, I'll just very briefly, Mr. Chairman, I would like to welcome our new Deputy Director, Erica Dorsey. Erica brings over 20 years of state service with a strong background in civil service and human resources programs, as well as compensation and classification experience. So we're excited to have Erica come aboard.
Start with a moment of silence.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And for requests to address the commission on items on the agenda. But all but Robert Burns we're going to defer the comments by the other people who requested until we get to those agenda items. But Mr. Burns, you would like to speak. And the reason we're deferring the others and not Mr. Burns, because the others are by the parties involved in the particular issue. And we know who you are, but go ahead and identify yourself.
Thank you, Mr. Chairman. I am Robert Burns of the video blog Sound Off, Louisiana. And I'm going to try to be as diplomatic as I can in what I'm going to deliver today, the comments I'm going to make. And I'm making comments on the items 2 and 3, the WAE, and I'm going to be emphatic that I believe that item should be denied. And I'm going to state why. I have been bombarded, and I do mean bombarded, with statements about the hiring practices of LSP, the promotional practices of LSP, and specifically, and I know a lot of times people don't want to talk about this, but that's why I'm not part of the mainstream media. I'm going to talk about it. And that is the claim that there is being extreme preference being shown by the current colonel to minorities. And it's quite prevalent out there that perception is going on. Made a public records request to substantiate this. I want to commend Executive Director Hanneman as well as Ms. Givens, because I knew that it was going to take at least about 30 days to fulfill that request, and they worked diligently on it. It is my intent to establish a table that will link every single resignation and or retirement that has taken place with LSP since Colonel Davis was appointed. Also gotten all of the promotion documents. That's why it took 30 days. That takes some time to compile, but I'm making this presentation today very similar to what I did with regard to the cheating scandal, given an advanced heads up. And I'm just putting it out there. The documents will show what the documents will show. I wouldn't want to have to repeat some of the commentary that has been provided to me with regard to those practices or the perception of those practices, specifically commentary that Colonel Davis made at Troop F, followed by commentary that he made at Troop A. And I would think that probably, I hope that everyone is not so out of touch with what's going on at the field level at LSP that you would be unaware of that, because if so, that's shocking. I'm not prepared to directly accuse, but I'm telling you, that's the sentiment of an awful lot of folk. And I mean, Jason, I'm sorry, I'm going to have to do a subsequent follow-up. I've been told there've been 10 more resignations just since you got me the material. So I'm sorry to put more work on you, but I'll be making the request for those 10. At least that's a lot less than previous. And I thank you again for your diligence. Is she back there? I don't know if Debbie's back there or not, but I only have one contact in. I know that was a lot of work, and I don't intend for it to go to waste. So I've given you the heads up. There were also 2 specific positions with regard to promotions that there was an enormous backlash on. Have those as well. So in my opinion, continuing to come up here meeting after meeting after meeting after meeting after meeting and putting Band-Aids on an insidious cancer is not the solution. So I'm calling upon this body today to issue a denial and have the practices that are causing so many troopers to resign come to an end. I'm sorry again to have to deliver this message. It's not something I would want. I think I was equally diligent since 2017, because if somebody says, well, why didn't you say anything about this kind of thing going on under previous administrations? Since I have followed state police, which started in January of 2017, I would challenge anyone to say that I have not come forward and divulged as much as I could, much as I possibly can, about wrongdoings regarding the other race. Stand behind that, and I'm very proud to have done it. I apologize for nothing. But if this is in fact going on, it's equally wrong to go in that direction. 2 wrongs don't make a right. And if it is going on, and I've only looked at some of the documentation, I will admit to that, but this is coming from an awful lot of folk. So I've said it. I know it's a sensitive matter that a lot of times people just won't talk about. And perhaps the mainstream media never will. But maybe that's why I'm a blogger and why I don't hesitate to go ahead and bring this out. I apologize for the fact I've had to, but I think it would be remiss if that factor is not addressed, because it is whether it's reality or not, it's a strong perception that's out there. And that specifically goes to comments made at Troop F, followed by less, it had to be toned down to Troop A. So, and if I was able to be there or I had a recording of it, would be great, because I'd love to be able to play it. Unfortunately, I don't. So with that, thank you, Mr. Chairman. I appreciate everyone's understanding. Thank you for not cutting me off, because I wondered if that might happen. You know, just being honest, because not that
I
you
don't
would.
think you've ever seen us cut people off
You have
because of the content of their message.
Thank you. That's what I meant. And I appreciate that. I was a little concerned that, every time you bring up something that's really, really sensitive, it's a possibility. Thank you. Thank each of you for hearing me out. And I'll have more to report either way in coming days and weeks. Thank you again.
Thank you, Mr. Burns.
You're welcome.
We move to item 6 on the agenda, the business items on the agenda, consideration of the meeting minutes from July 14, 2022. Do we have any motions?
So moved, Mr. Chair.
So we have a motion and the second to approve the minutes. Any discussion? All in favor?
Aye.
Any opposed? The ayes have it. The minutes are approved. We have consideration of motion, item number 2. Consideration motion to ratify the executive director's interim reauthorization of 7 part-time WAE positions through October the 13th, which is today, I assume, through today, in accordance with SPC Rule 3.1N. And obviously, this is simply ratification of the action up until today. It has no bearing on the question of the merits of those issues when we discuss them in the next couple of items. Do we have any motions?
I would so move.
Have a
Mr.
motion
Chairman.
by Commissioner Knapp. Do we have a second? A second
Second.
by, okay, and so we have a motion and a second, and any discussion? All in favor?
Aye.
Any opposed? The ayes have it. Thank you. Okay, item number 3, consideration of a request from the Office of State Police for a 2-year reauthorization of 10 part-time WAE positions. And we do have a representative here to speak. And again, despite our knowledge of who you are, for the record, go ahead and identify yourself.
Yes, sir. Good morning, Mr. Commissioner and Commissioners. It's a great morning to be here again to have this discussion and seek requests for reauthorization of these much needed positions that we have across the department that represent our WAE positions. Since we last met, the position that we've been working on is to definitely do a top to bottom review and evaluation of all of our WAE positions with the help of our human resources director, Ginger Craig, and our team over there. We've been working diligently to find and evaluate those positions that we can either make permanent or dissolve. Today, we're talking or requesting for approval for 10 WAE renewals. The 10 positions all respectively handle essential duties that if they were not filled by WAE, we would have to have a trooper in those positions. And as you know, the department's current status with personnel is very dire. We're working on, I say dire, but we're working to fill some 187 vacant positions, which is the need for the WAE program and the positions that we're requesting to renew. Our team, as far as recruiters and our training academy, are working hard to make sure that we can continue to work efficiently and effectively with the positions that are allowed in our TO. However, today's request to renew these WAE positions come with your request or permission to move forward so that we can continue the mission and the operational request that's needed for our public safety services. So I stand to answer any questions that you may have for those particular positions. There are 10 that's listed, and I have all of them in detail if you want to know specifically to the duties of each one, Mr. Commissioner.
Any commissioners have any questions? So it says they're part-time. How part-time is part-time?
So as you know, we do a 2-year request right now, and we do evaluate them, hence today. The ones that are up to date, we do see that they continue to be a need. For example, one represents our training academy firearms section. To hire or fill that position right now, basically we would have to hire more troopers to bring on the department and train to put in those sections. To be without that filled position would hamper the training that's required for our firearms and training post certifications that are required across the board. So to answer your question, how part-time are they? They're part-time as long as we have a need to fill the vacant positions with a trooper. We hope to make it permanent at some point, but that the hindrance is that we do not have a trooper position filled that will cover that particular need.
I guess my definition of part-time and yours may differ. When I think about part-time, I think someone who's working less than full-time.
Yes, sir. Yes, sir.
I didn't get an answer to that question.
Right quick. They're restricted to a certain number of hours per week, Mr. Commissioner. They're not working like full-time 80, in some cases 80 hours. They're restricted to a certain number of hours per week. I'm trying to find that document for you. If you give me a minute. Let's see. I can get the total numbers for you. I don't want to delay the time, but they are, to your point, they're not working full-time hours as an 80-hour per se rotation within a 2-week period. They're restricted on the number of hours based on the status of being a WAE.
The next time y'all come before the commission asking for approval, I think it's pertinent information for us to have.
Yes, sir.
So would you please be prepared to provide that information to us at the next request, which brings up my next question. It seems like we have these requests every meeting that we have. Is there not a way to anticipate the need for these requests so that you can anticipate what you're gonna need for the next 3 or 4 months and then come and get an approval instead of come to us every time we have a meeting with these requests?
Well, Mr. Chairman, as I understand it, I believe that was the request of the commission. From when I took over, I learned that to come before the commission every time we have a expired WAE or as it is expiring, we need to seek the approval to have that position reauthorized.
I agree with you. That is the commission's position, but my point is, can't we anticipate that it's going to be expiring within the next 3 or 4 months so that you could get your approval instead of waiting right until the time that you got 10 this time and you got 10 next time, you had 10 last time, and I don't know those exact numbers.
No, I appreciate that question.
See what I'm
And
saying?
no, yes, sir, Mr. Commissioner, you're thinking, I'm thinking the same thing. I can tell you what I do understand that I believe 5 of these were requested prior to this meeting, but because we didn't have a commission meeting last couple of months, they did expire. Our rule and practice, since I've been sitting in the seat, and I know prior to me, previous chief of staff, Chief Kane, we request that each lieutenant colonel, deputy superintendent have these requests come in at least 2 months before they're expiring so that we do not delay those positions or come before you with an expired WAE position request.
And right now, I'm not talking about the ones that expired in the executive director had to interim do the approval. Yes, we did not meet last month, and that's nobody's fault. It's just was the circumstances. It's not your fault. But my point is, once you ask the colonel to give you the upcoming list 5 or 6 months in advance so that you're not here. Yeah, yes, sir.
Mr. Chairman, I was just going to add that they are, the requests do have a staggered expiration date, and some of them are looking to expire in November, the end of this month, and in January. So there are some that were submitted in advance. And I believe at one point when we set these up, there was a request for about 40 of them at one time, and that was very large to get into the details at that time. So we did 2 years ago, I believe, break it up into smaller bites, but then also trying to, like you said, get several months at a time together. But just so how things fell the last meetings and the spacing of the last meetings,
And Mr. Chairman, if I may add, I completely agree with you. We do not want to come at the last minute with a request. That's not the way I choose to operate as well. So I hope that you would see with these requests, we're trying to come very timely on those requests.
If I can.
Yes, yes, sir.
Maybe what we shoot for is starting next year, we do it quarterly. You know, maybe come in, 4 times a year and have it anticipated for what's going to fall through that next quarter,
Definitely.
and maybe take a shot at doing it that way. And see if that's a middle ground that works with everybody.
We definitely look at that and consider that, and whatever work. I don't want to come every time, this is.
First quarter, we would have to do 2, obviously 1 for the first quarter, and then sometime in the first quarter, then it would pick up to take care of second quarter, come into the third quarter. And that way, if there's a reason why there's not a meeting 1 month or another month, it's not pushing it too far towards the end. And then I think that would be a really kind of good common middle ground for that.
Completely agree. We'll definitely work on putting that in place.
Thank you.
Any other questions or comments? Do we have any motions?
Make the motion to approve.
Any further discussion? All in favor?
Aye.
Any opposed? The ayes have it.
Thank you, sir. Thank you.
Okay, the next business item on the agenda is consideration of motions filed, excuse me, in the matter of Cody Williams, Department of Public Safety and Corrections, Office of State Police, docket number 22-263-S. And we have oral arguments on.
Good morning, Your Honor. Floyd Falcon on behalf of Cody Williams.
Is there a representative for the department?
It's my understanding, Your Honor, the motion was unopposed. There was a deadline to submit memorandum and so forth, and they did not choose to submit a memorandum.
Michelle Gerard on behalf of the Department of Public Safety, Office of State Police. No opposition was filed by the agency in this matter.
Is that an indication that the agency has no opposition, or that just no opposition was filed?
There was no opposition presented. The agency does not oppose the motion.
Agency does not oppose the motion.
That is correct.
Okay. Proceed. Mr. Val. My mama told me a long time ago, when you're ahead, you talk fast and you sit down.
Ask you to grant the motion. I'd be happy to explain my theory, but
Briefly.
okay. What put me on notice, we had a pending appeal in Mr. Williams' case, and I got to looking at the letter of Captain Larberdane explaining exactly what they did it's dated December 23rd, 2021, as referred to in my motion. And it revealed that on April of 2021, a special committee tasked with review of body cameras discovered the use of force at issue in the appeal. Well, the letter of suspension didn't come until almost, actually 13 months later. They didn't institute the investigation within 11 days of them, within 14 days of them discovering the event. There was no formal complaint. It got sent to the body camera thing for review. They reviewed it. It was Captain Fontenot is the commander of that unit. Under the rule 12.18, if no formal complaint is made against a trooper, but an incident justifies an investigation, the appointing authority shall cause an investigation to be initiated within 14 days of the date that internal affairs, the troop commander, or section commander, anyone above commander learns of the incident. Well, Captain Larverdane's letter told me that they learned of it in April in 21, and the disciplinary action was months and months later. No investigation was started within 14 days. And therefore, I would like to, it's a little bit more complex than that. In the cases I've handled here, we usually have a letter of discipline. In this case, we had a letter of discipline and we had a letter of admonishment, or a letter of, let's see exactly what they called it, a letter of counseling. I understand it's not a disciplinary action, but if you believe that my theory is correct about not timely instituting the disciplinary action or instituting the investigation, then just we should maybe think about giving this man a clean record on this issue by withdrawing or ordering the withdrawal of that letter of comment against him. And I realize that that's not part of an appeal because it's not a disciplinary action, but I think it would be the right thing to do. The letter of counseling and the letter of suspension arose out of the same incident. So I don't know how y'all want to handle it. I realize it's not, there was nothing in the rules that I saw that addresses that issue. So I'm addressing it now.
Let's make sure we get a clean understanding of what it is you have prayed for in your motion. What did you pray for in your motion?
In my motion, I said, Cody Williams prays that the 8-hour suspension be set aside, that he receive back pay and reasonable attorney's fees. I said additionally.
That is the motion that is before us.
Yes, sir. And then it goes on. I said, additionally, in the interest of fair play, I realize I don't have a right to it. I mean, I don't have a right to bring an appeal on this, that the letter of counseling should be recalled and stricken from his personal records and the records of the department. That's what I'm asking for. And I sort of demanding the first one and hoping y'all give this man some consideration on the second issue on the letter of counseling.
Although we don't always like to be politically correct, I'll politically correct you and say you are praying for the first one. And
Well, some people call it, sometimes they call it demands, but you're right, it is in the prayer. It is in the, I have a hard time bending down, get on my knees. I got a bad back.
In my other roles in my life, I would be happy to sit down and talk to you about that. In this role in my life, we'll save that for another day.
Yes, sir. In addition to that, I have well.
You do recognize that this commission has taken the position in the past that violations of those timelines don't necessarily result in overturning.
I understand that y'all have sometimes overturned and sometimes not overturned.
Well,
I guess that's why we pray.
We have taken the position, however, that it legally, it does not mandate that it be overturned.
I understand that if that's the position y'all take, that's whatever y'all take, we'll appeal from it.
Well, I'm really putting that on the table because I would like to hear from the department. If you don't, I'm not trying to put you on the spot, but we need to know what the department's position is. You do not oppose the motion, period, end of comment?
I was advised to not oppose the motion, Your Honor, on behalf of the agency. With regards to the issue of the counseling, I do want to point out that they're two separate sets of facts and circumstances, but no opposition was filed because the agency didn't oppose the motion.
All right.
I don't have anything further to add.
All right. I
We'll
appreciate-
defer to the
I-
commission on that.
I just wanted,
Yes,
I
sir.
just wanted to get a clear understanding of the agency's position. All right, any other questions? Okay, we entertain a motion to go into executive session.
Move. Second.
So moved and second to go into executive session in order to discuss the issue of allegations of misconduct. Any discussion on that motion? Take a roll call, please.
Jared Ricky,
Yes.
Leonard Knapp,
Yes.
Monty Matalago,
Yes.
Brian Crawford,
Yes.
Erica Dorsey. Oh, I'm sorry. Scratch Erica. And Euless Simeon. Euless Simeon.
Yeah, I'm sorry, I was still stuck on Erica. Yes.
It's falling off. The hat was falling off.
Missing you, Mr. Burns.
I wasn't gonna tell him no, so. I quit taking down the stand and try to minimize the time. You don't hear that sound? That's not good, but it's on now.
So we'll entertain a motion to leave executive session and come back into public meeting.
So move.
Second.
Moved and seconded. Take a roll call, please.
Jared Ricky,
Yes.
Leonard Knapp,
Yes.
Monty Matalako,
Yes.
Brian Crawford,
Yes.
and Euless Simeon.
Yes. At this point, we'll open the discussion, public discussion, any possible motions or vote.
Mr. Chairman,
Yes, sir.
I
Commissioner
move to
Crawford.
grant the motion of summary disposition and to set aside the 8-hour suspension in the matter of Cody Williams, docket number 22263-5, as well as awarding $750 in attorney's fees.
Second.
Oh, and you. Let's see, did you mention about the back pay?
As well as awarding the back pay.
I didn't hear what you said about attorney's fees.
Attorney fees up to $750.
I'll amend my second.
All right, we've been moved and seconded. Any discussion? All in favor?
Aye.
Any opposed? The ayes have it.
Any action on the letter of counseling?
It's not an appealable matter.
I agree. I thought y'all just might be overwhelmed by it being the right thing.
I was quite overwhelmed, Mr. Falcon. but-
Thank you, sir.
The next item on the agenda is consideration of motions filed in the matter of Daniel Fontenot, Department of Public Safety and Corrections, Office of State Police, docket number 22-260-S. Morning, ma'am. Again.
Morning, Michelle Gerard, on behalf of Office of State Police, we do oppose this motion.
All right, I kind of figured that when you jumped up to the seat there.
And Michael Anton for Mr. Fontenot, sir.
Good morning, sir.
Good morning.
It's your motion.
Sir, we filed a motion for summary disposition. We feel that the facts show that he's clearly entitled to the relief that he sought. What we have is a very good trooper, 20 years, master trooper. He trains he's a DRE instructor, LiDAR instructor, SFST instructor. He served the state police honorably. He's got no blemishes on his record thus far. He is a by the book type of officer. The facts are not in dispute. There was another trooper whose performance was not as stellar as his, not even almost, to the point that it was affecting troop morale. It was causing issues. He went to his superiors and he asked them to intervene, to correct the situation. And they effectively said, handle it yourselves. So he did. And under the commission job specifications that are online, for master trooper, he has the ability to exercise functional supervision over subordinate officers. So while in uniform, in his patrol car, on duty, and while she was in uniform, in her patrol unit and on duty, he counseled her in order to protect himself, to protect the state police and protect the department from potential retaliation. Her maybe saying that, the conversation went away, that it didn't go. He activated his body worn camera, again, while on duty and in the discharge of his official duties, to document the conversation, just in case she ever filed something frivolous saying that the conversation did not go the way that it did. He did not weaponize this against her. He didn't tell anybody about it. He saved it in the system. He didn't spread it to other troopers. He didn't go tell his buddies that, they had this counseling session. It was purely to protect himself and promote the future efficiency of the department because as we all know, litigation is inefficient. And documenting the situation would show exactly what occurred. And there's no question as to what occurred. It's on video. There's never been an allegation that he did anything inappropriate. The LSP is simply mad that he recorded the conversation. He presented himself to IA, gave a full and truthful account of what had occurred. And frankly, we were floored when we learned of the decision to discipline him for violation of the body worn camera policy, which states that troopers are not supposed to record one another except in the discharge of their official duties. And there's also a little open door provision in the body worn camera policy that says that we cannot contemplate every situation where a trooper may need to use his body camera. We just can't. And therefore, whenever a trooper thinks it is valuable and necessary to document an incident, he may use his body camera. This is a by the book kind of trooper. He knows policy. He did what he thought was in accordance with policy. Several other troopers, including sergeants, retired sergeants, other master troopers, have given affidavits that he is not the type to violate policy. He's actually the exact opposite. He's the kind of cop that bad cops don't want to have around. There was absolutely no bad faith in what he did. And
Isn't that a question of fact?
of bad faith?
Yeah, whether he did or did not act in bad faith, isn't that a question of fact? I'm not prejudging
Yeah.
it one way or the other, but isn't that a question of fact?
Well, it can be, sir, but if
But
it is it a
can-
material
if it can
fact?
be-
The question is
but
whether
if
it's
it can be- Can I finish my question?
sure.
first?
Yes, sir. Yes, sir.
All right, if it can be, how can we decide this on a summary disposition?
Because I don't think it's a material fact. Even whether it's a fact or not, the question is, did the actions violate policy? And under the black letter wording of policy, we don't believe he did. And furthermore, another trooper,
We have to determine the facts in order to decide whether it violated the policy.
well, the policy doesn't have a provision that says if it's done in good faith, it's okay. If it's done in bad faith, it's not. It just says that a trooper can use his body worn camera in the discharge of his official duties. I don't think it's disputed that he was on
Don't we
duty.
have to determine whether or not this was in the discharge of his duties? Actually,
I don't think there's been anything presented by the department in their opposition that opposes whether or not he was on duty, whether or not he was discussing his official duties with another trooper who was in her official duties and also on duty. And when a mover presents something and it's not rebutted, then it's accepted.
but in a discretionary act, you would agree that was a discretionary act on his part, right?
To record? Sure.
In a discretionary act, don't we have to consider the motivation of the actor in determining whether or not it was done in furtherance of his capacity in his official duties?
And again, the circumstances indicate nothing to the contrary.
We have
Of
to make that factual determination, all right?
not really, no, sir, because with a summary judgment, if facts are not disputed, and there have been no,
I understand summary judgment thoroughly. I've been doing
Sure.
it for the last 41 years.
sure,
Okay, but my question was, that would be a material fact, would it not?
which facts, sir?
The fact of the motivation with which he acted in at the time to determine whether or not it was done in furtherance of his duties.
Sir, I think the step one is determining whether or not his actions violated policy. And I do understand what you're saying that, but if he was in the discharge of his official duties and that has not been rebutted, then I don't even know that we need to get to motivations and things. I briefed it
Okay,
extensively.
but there's a difference. We can't conflate everything together. I don't think, and I don't want to speak for the department, but even if I accept that what he was doing in this counseling session, is that what you want to call it, a counseling session? I don't think anyone, at least I'll accept for the purposes of your argument, that the counseling session was in the furtherance of his duties. The question, though, is whether or not the use of the body camera was in the furtherance of his official duties, right?
Sure.
So is there not a question of fact that has to be determined as to whether or not his motivation was such to take that action outside of his official duties?
Well, and does a question of fact exist? It does. We briefed it, but I don't believe that it's a material fact because I believe, but whether he was on duty, discussing issues concerning his official duties with another trooper who was also on duty, applying that alone to the black letter rules, the policy, he's within policy. The motivations is a secondary question that I don't think is material to the determination.
So you would argue that as long as it's within that first part of the rule, we don't worry about motivation. That's your legal argument.
Yes, sir. Yeah.
Okay.
Yeah.
I now understand your legal argument. I'm not
Yes, sir.
saying I agree or disagree with it, but I now
Right.
understand where you're going. Okay.
Yeah.
But if I were to disagree with it and we had to get to the second part of it, how do we, would you agree with me that if we have to get to the second part, that becomes a factual question?
It would. And again, I would posit to you, sir, that we have presented affidavits, which are perfectly allowable under the rules, and other information that set forth and that support the contention that it was all good faith. And there's been nothing presented to rebut that at all, except statements that the appointing authority simply disagrees. And he wasn't there. He's not a factual witness. There's absolutely no circumstances that rebut that his motivations were in good faith. So
You would
then
say it's not in dispute,
it's not in dispute.
material, but not in dispute.
Not in dispute. So as far as the mechanical recording policy is concerned, I believe that is a legal determination that does not require any issues of fact. I briefed that extensively. The policies do not cross-reference one another. The mechanical policy was in effect long before the body-worn camera policy was in effect. The mechanical policy is worded in a way that it does not reference the use of body cameras. They're distinct. You've got digital versus mechanical. He interpreted that and did not feel he was in violation of it. We have an affidavit from Dr. Steve Thompson. He was a 10-year trooper. He has military experience. He was a military police sergeant. He's got his PhD in public safety, teaches at McNeese and trains at the Southwest Louisiana Training Academy. He was Trooper Fontenot's FTO. And he presented an affidavit in conjunction with this saying, I would have trained him to record that conversation. It was official duties. And it was well known at the time that we were training Trooper Fontenot that the mechanical recording policy didn't apply to body-worn cameras. And I would have trained him that it didn't apply to body-worn cameras. So now we have another fact that is not in dispute, that he just acted in accordance with his training. Moving on to the conduct unbecoming argument, I really don't know where that came from. Dr. Thompson also teaches policy interpretation and application, particularly with regard to whether they have ethical motivations. And he thinks, well, he is put in his affidavit that he just sees no basis for the conduct unbecoming. I'm really not sure what it's based on, except something to do with the conversation that he had with his superiors and how he recounted it to IA, and how that was just an honest account of what occurred. He went to his superiors. He asked them for support. They refused to step in. The burden fell on him. He did his duty rather than neglect his duty by addressing the situation. And somehow that constitutes conduct unbecoming. The facts just don't support that. And at the end of the day, even if there were some sort of violation with regard to any of this, the case law is clear that in order for there to be calls to discipline, there must be a real and substantial impairment of the efficient operations of the agency. And I don't think there has not been any real and substantial impairment to the operations. Sergeant Chris Hill presented an affidavit saying he has never heard of anyone being disciplined for actually using their body camera. I can tell you as a defense attorney, if I had an officer on the stand and asked him if he had a blemish on his record, and he said, yeah, and I said, what for? For using my body camera. It would be surprising at the least. If anything, what Trooper Fontenot did was in the furtherance of the efficient operation of the agency. by remedying the poor work performance of another trooper and by protecting himself and the department from potential suits by recording it and saving it to document exactly what occurred, which is exactly what body worn cameras are for. As a criminal defense attorney, I can tell you more times than not, 9.5 times out of 10, that camera footage proves my client did something wrong. It covers the police. It shows that there was no excessive force used, even though the client says there was. It is a method to accurately and objectively document a situation to protect the officer and the agency from improper litigation, which necessarily promotes the efficiency of the agency and its operations. And for those reasons, we ask that our motion for summary disposition be granted. And I'm happy to answer any questions that you have of me.
Any other questions? Mr. Romer?
Good morning. I feel like I'm arguing the facts here that should be at a hearing where we have witnesses and testimony for the commission to make a decision. But this is a motion for summary disposition. And although the appellant did file a lot of affidavits, although I would argue that they're irrelevant to the matter at hand, what you can also consider is the letter of discipline. You have the appointing authority's statement of the facts and his opinion and interpretation of state police policy, which is very relevant to this matter. You have not heard from the appointing authority other than in the letter. So when we get to the facts are that you had a trooper who took it upon himself to do the duties of a supervisor. Whether he thought the supervisors were acting appropriately or not is not for him to decide. Engages in a conversation with another trooper and records it on his body camera that is in violation of policy.
Was there a direction to him to handle the matter?
He said he was ordered to. No one has said he was ordered to do it. He took it upon himself, according to the statements obtained during the investigation. So a decision of, I'm going to do this because I don't like what another trooper's doing versus a supervisor ordering him to do it are two clearly different things. The policy says.
Where are the facts that dispute that claim? You're saying that that there's a dispute over whether he was ordered to do it or not. Did you submit anything that disputed that fact?
I'm not aware of anything, any affidavit from any supervisor in the motion for summary disposition that says he was ordered to do it. The letter says that he had a conversation with a supervisor who said, handle it amongst yourselves. That doesn't mean go speak to her and record it. He could have had the conversation in the presence of another supervisor. If he was concerned that something might have been said during the conversation, he could have either avoided the conversation or had someone else present during the conversation. But instead, he violated the policy when he used his body camera. So if he wants to take the position that it wasn't a mechanical recording, which I'm just not following, if you don't know what a body camera is, it's a device they wear, and you have to begin the recording somehow, and you either push a button or something triggers it. And I believe in this case, he didn't activate his lights, so he would have triggered it by pushing a button. That's mechanical in my interpretation of what mechanical is. Whether the recording was digital or a little wheel turns to put it on a tape, he mechanically recorded that. He didn't sit and transcribe it by hand. So the appointing authority has already reviewed the facts as stated in the letter. And I'm going to point out that appellant doesn't dispute the facts, that the incident happened, that he activated his body camera and recorded the conversation. Those are material facts that aren't in dispute. Whether or not the policy was violated is in dispute. And how can you make a decision without hearing the testimony and evidence? The affidavits that are attached, I would argue, are relevant. If you've read them, and I hope you have the 76 pages that was presented in the motion and the affidavits, we have statements regarding another trooper's ability to function as a DRE, which is completely irrelevant. We have an affidavit from someone in the military who's never served in state police, which is
Let's
irrelevant.
put aside the affidavits. I want to talk about the legal argument. What about his legal argument that the recording was done in furtherance of his duties and therefore it's not a violation.
I'm not aware of any duty that he had to go meet with the trooper and counsel her. He's not her supervisor. So the agency's going to take the position. It wasn't a duty he had.
Well, I'm be fair.
But
But-
that whole issue's in dispute is the point here. I mean, for the commission to sit here and make a decision without hearing any testimony on the situation, you have the appointing authority's letter. If we need to start drafting letters in affidavit format, for the colonel in a sworn affidavit to state, I find the trooper violated policy, we can do that. But, you know, these are material facts that the trier of fact has to hear all the testimony and evidence to make these decisions. When you're talking about an opinion
But the
on
whether
a
he
policy.
whether he violated policy or not is really a legal question. So we have to rely on the facts right now in the letter, but we can look at that, and I'm not disputing that. To you was the legal question of whether or not you would agree with his argument from a legal standpoint that if the body camera was turned on in fulfillment and the course of his duties, that does not violate the policy.
Well, I mean, I'm going to say that's the appointing authority's decision, and he must have made that determination in the letter. If we're going to question was it his duty or not, I think we have to have testimony on that. So what you want to do, because, you know, you're trying to remedy something that you believe is a problem versus you're a supervisor and someone's performing their duties. I mean, I think that's a question for the appointing authority.
You can go ahead. I just wanted to do that question.
I was speaking about the affidavits. I think we're trying to cloud all the issues here with the 76 pages and all the affidavits submitted. I went through it and the majority of it, I believe, is irrelevant and not necessary for this commission to make a decision as to whether or not the policy was violated. He brought up Mr. Thompson. He retired from state police in 2013, according to his affidavit. I don't believe state police had body cameras in 2013, so I don't know how he would have or could have trained him on when it was appropriate to use the body camera or not. Another affidavit talks about his fellow troopers' DRE status, which is irrelevant to the proceeding, and I'm really confused as to why there's an official state police report of an evaluation in there with someone's name on it, what that has to do with the facts here about him recording his conversation with his fellow trooper. So we also asked that not only the summary disposition be denied, but all these materials be stricken from the record as they're irrelevant to the facts at hand here. Also, interestingly, if you read through, and I don't know if we're going to have another motion argued after this, but if you read through it, this has become an attack on the trooper that was the other party to the conversation who was recorded. Some allegations in there that there was a need to record the conversation. And if those are true, if he was so worried, he could have just avoided the conversation, period. But Trooper Fontenot put himself in this position. So for these reasons, the facts are what occurred. The appointing authority has outlined the conduct that occurred. He also made his determination of the policies that were violated. The facts outlining the conduct have never been challenged. In fact, they've been admitted by the appellant. So where we are, the material, the questions that remain are whether or not policy was violated. And that can't be decided based upon the information presented here. You have the letter, the appointing authority's opinion and decision in there. And without any testimony as to whether or not it was violated and how the fact pattern violates the policy, we think summary disposition is inappropriate at this time, and it should be referred to the hearing on the merits.
Brief response.
Yes, sir. Maybe I got ahead of myself with my legal argument earlier. It all starts with what is summary judgment. When both parties have an opportunity to conduct adequate discovery and certain facts are no longer in dispute, then there's no issue of genuine material fact. The court can make a ruling, or in this case, the commission, on how those facts apply to the law. One party cannot simply not participate in the discovery process and then say, this is a matter for trial because we got facts we got to decide. We're conflating the appointing authority's capacity as arbiter and fact witness. He has already determined that this is against policy in his opinion, and that's fine. But now it's the commission's turn to decide if what happened is against policy. They could have presented affidavits. They could have presented witness testimony. We have the disciplinary letter, and I understand the commission's going to accept all of that as fact. That is their facts. I have submitted facts, most of which are not disputed and that are material. And when you look at their undisputed facts and our undisputed facts on the issues that matter, the genuine issues that are decided now, no one's disputed them, we're still entitled to relief as a matter of law. Summary disposition is absolutely appropriate. The department could have presented any witnesses, any affidavits, any other,
Any witnesses?
well, in any event, other facts that they wanted to dispute ours, and that did not occur. The but in any event, I wanted to bring that up. And as far as the relevancy of the affidavits, they're relevant. In each item we have presented is relevant on a certain point, and many of them are relevant on other points. To establish, we're talking about the complaints that this trooper filed after the fact. That just shows that Trooper Fontenot's gut feeling was correct in the beginning, that there could be retaliation if he didn't document that conversation. The affidavits speak to what a good trooper he is and to his performance. The affidavits also speak to whether or not some of these issues were occurring to a frequency and degree to which it would have been reasonable for him to feel like he needed to step in and correct it to promote the efficiency of the department. And to say that she's not a subordinate, the way I read the specifications on the commission website, which he actually cited in the IA report, is that a master trooper can exercise functional superiority over subordinates. He's been there 20 years. Sergeant Salmasina said in his affidavit, that's what a master trooper's for, to handle problems before it gets to a sergeant, if it can be handled by a master trooper. He did absolutely nothing inappropriate, and he sought their intervention. He was denied their intervention and told, y'all can talk it out. It may not have been couched in the formal terms of, I'm ordering you to go talk it out, but at the very least, it's an authorization, and it's how he interpreted it. Regardless of that, any day of the week, just as a member of the public, I would want a good cop to make sure that things are running as efficiently as possible, rather than turning a blind eye to inefficiency. And that's what he did, and he's been punished for it. And we're asking the commission to do the right thing as the neutral arbiter, somebody that doesn't have a dog in this fight. Many of you are in law enforcement. You know how hard it is when you're picking up slack because somebody else isn't. It's a hard job. Everybody's got to carry their weight. It was affecting morale, and he did what he thought he needed to do for the troop. If that is censurable, then that is regrettable. And if his interpretation of policy is incorrect, the policies that were given to him, and he was just told to read them and learn them without any instruction on their meaning, then a letter of counseling is more than appropriate to redress the situation.
Questions or comments? Any other commissioners?
One thing I would like to point out, Mr. Chairman,
Extremely
is
brief.
there is no discovery in these proceedings. We have not had the opportunity to engage in discovery,
We're-
take
we're familiar with the
depositions.
process.
Thank you.
All right, thank you. Right, any questions? Right, we'll entertain a motion to go into executive session to discuss the allegations.
Second.
To discuss the allegations of misconduct. You gotta make the record. All in favor, please take a roll call, but
Jared Ricky,
Yes.
Leonard Knapp,
Yes.
Monty Matalago,
Yes.
Brian Crawford.
Yes.
And Euless Simeon.
yes. Okay, make sure everybody takes all of their belongings. entertain a motion to come back into public session.
So moved.
So moved and seconded. Roll call vote, please.
Jared Ricky,
Yes.
Leonard Knapp,
Yes.
Monty Matalago,
Yes.
Ryan Crawford.
Yes.
And Eula Simeon.
Yes. Okay, any discussion at this point, or do we have any motions?
Make a motion, Mr. Chairman. This is in the matter of Daniel Fontenot, docket number 22-260-S. There was a motion made for summary disposition of the appeal by the trooper, Daniel Fontenot, and on that behalf, I would move that we dismiss the request for summary disposition.
Second.
Then moved and seconded. Any discussion? Obviously, a vote on this issue is not a vote on the merits of the discipline. It's simply a vote on whether we as a commission feel that we are in a position to summarily decide those issues without the presentation of evidence. So, any other discussion? All in favor?
Aye.
Any opposed? The ayes have it. So the motion for summary disposition is denied, and we'll set the matter for a hearing.
Yeah, and I'd like to talk to the parties for a second.
Thank you.
The next item on the agenda is consideration of formal charges filed by Ashton O'Dwyer Jr. alleging members of Louisiana State Police engaged in criminal conduct and violated his civil rights. This is obviously a matter that involves allegations of misconduct and ethical violations of his civil rights, and would entertain a motion again to go into executive session. It's been moved.
Second.
Seconded. We'll take a roll call vote, please.
Jared Ricky,
Yes.
Leonard Knapp,
Yes.
Monty Matalago,
Yes.
Brian Crawford.
Yes.
Eula Simeon.
Yes, with the notation that everybody's getting their exercise today. Ready on this side too?
Yes, sir.
Okay, we'll go ahead and come back into order. Entertain a motion to go back into public session.
I'll move.
Been moved
Second.
and seconded. Take a roll call, please, ma'am.
Brian, Jared Ricky,
Yes.
Leonard Knapp,
Yes.
Monty Montalvo,
Yes.
Brian Crawford,
Yes.
and Eunice Simeon.
Yes, before we get into a discussion of item 6 on the agenda, I understand Mr. Antune would like to make a brief comment to the commission.
Yes, sir, and I apologize for the tardiness of this. If I may, I'd just like to lodge objection to the motion and the ruling of the commission in the matter of Daniel Fonda.
Thank you, sir.
Thank you, sir. Appreciate it.
With that, we'll move into public discussion of the consideration of formal charges, a request for formal charges filed by Mr. Anton Ashton Dwyer Jr. Any discussion or any motions?
I'd like to make a motion. I'd move that we decline to investigate under our rule 16.5.A1. Jason, I appreciate everything you've been sending us on this. It's been quite voluminous. It's been constantly flowing in, and I've read it. I've read quite a bit. I'm sure everybody else has too. But the reality of the situation and why I'm making this motion is, of the 5 named respondents, one of them is the Office of State Police, which is not a classified employee. 3 of the human beings are not classified employees. And even if everything that Mr. O'Dwyer is telling us is true, and I'm not saying it is or it isn't, but even if it was, it's still not a violation of Article 10, Sections 41 through 51 of the state constitution or the rules that we have. So there's just no reason for this, as far as I'm concerned.
Been motion moved. Any second?
Second.
Okay, Mr. Hanneman, we do need an attestation from you as to whether or not you provided the commissioners with all of the documents.
Yeah.
And in communications from Mr. O'Dwyer.
Yes, Mr. Chairman. Yeah, I want to be very clear from Mr. O'Dwyer that I have received multiple additional communications via telephone and email from Mr. O'Dwyer since he last appeared before you in June. And I've shared all the correspondence with you. Place that correspondence in your binders, including the email he submitted yesterday as well as early this morning. And I just wanted to make you aware that everything has been provided for your consideration today.
Been moved and seconded. Any further discussion? All in favor of the motion, say aye.
Aye.
Any opposed? The ayes have it. So the commission will not institute an investigation. Next item on the agenda is public hearing to consider proposed rule changes to state police commission rules as detailed in General Circular number 228. That item was previously tabled and set to come back up for consideration today. Do we have any motions relative to that?
Mr. Chair,
Yes, sir.
I'd like to invite Colonel Chavez Cameron to discuss the newly created professional standards and compliance section that may correlate to some of these rule changes that we're looking at.
Morning, sir.
All right, thank you again, Mr. Chairman. Chavez Cameron, State Police, thank you for the invitation to come and speak to you again. I know as we get ready to consider these, the rules that we've discussed and had meetings about previously, I just wanted to share or enlighten you on some of the progress that the department is making to also better the operations that we're doing, and especially speaking to the considerations of these rules. We just recently, the Colonel launched professional standards and compliance section. And the hopes of that section was that we would focus on unifying the department's organizational vision across the board, specifically, but not restricted to our procedural justice piece as we're launching that training across the department. and in line with the fair and impartial policing practices, as well as this de-escalation training. The professional standards and compliance section will focus on tying all these pieces together and also taking a top to bottom look at all of our policies to ensure that we are holding our troopers accountable, focusing on transparency and working to build the trust back from the community, as well as those that we're serving across the state, as well as the troopers that are working and personnel that are working within the department. Not sure if you've been briefed on it, but I wanted to bring that at least to your attention, make you aware that this particular section for us, we feel really good about, as well as you know, the department launched a force investigative unit that also focuses on use of force investigations. These types of implementations are what we're looking at to hopefully gain your trust, gain your respect, to focus on just holding our personnel accountable, and that the things that we've had concern about hopefully will be put to rest moving forward. Thank you.
Thank you.
Thank you.
In my research, just in its last fiscal year, state police has made 17 changes or additions to policy and procedure, which I would say, are all in line with what we're all trying, are all common goal. So kudos to this new section and these recent changes.
Colonel, you said you weren't sure if we had been briefed, and I'll answer that. No, we have.
Yes,
And that's kind of my concern today. Going back, 2 years, the chairman, myself, and others have been working on these rule changes. And we appreciate now what's going on. But my concern is the rule changes that y'all are making, which are all very good. I mean, from what I've heard and what I've read, it's a very good thing for what we're all trying to accomplish here.
Yes, sir.
But we're not fully briefed. And moreover, we're not fully briefed as to what's coming down the pipeline in the next 30, 60, 90 days. Did you see what my real concern is? In a void 2 years ago, we sat down and started working on rule changes. And everything that's happened since then has happened. So now there's I don't want to use the word rush to make changes, but there's positive changes happening, which we all appreciate. But what I don't want to do is take something that we've been working on in unison with all three parties. And now we've got something that we're getting ready to vote on that may be redundant, unnecessary, or in conflict, direct conflict to what y'all are proposing or what may be coming down the pipeline, like I said, in the next 30, 60, 90 days. So I don't want to vote on something in that void, if you will, without knowing what else is coming down the pipeline. How do we bridge this?
So thank you again, Mr. Commissioner, for that comment. And I'm glad you mentioned that, because I really want to also offer, as you know, a lot of this stuff is work in progress.
Yeah.
We've been having meetings with the executive director, also meeting internally with a lot of our folks, stakeholders that surround the policy and are touching the disciplinary piece. There's some serious discussion that we've all been having, and we have not gotten to that finish line yet as it relates to the changes that you'll be considering. I hope that hopefully you can hear me today and my passion and concern for us all moving forward to work together. I completely agree with you. And I vow that we can possibly move to set some type of briefing so that the commission is briefed on our progress and what we're working on, the feedback and recommendations as it relates to the DOJ and the Bowman Group's assessment. I believe that would definitely fall in good favor or in good light with the things that we're trying to move forward and make better as we implement. We're launching a series, as Commissioner Montalvo mentioned, policies. As you know, with adversity, I've always heard adversity will introduce a man or woman to himself or herself. So we've had to take a hard look in the mirror at some things and look at what can we do to better our department. We're moving fast. We're moving at a fast pace, technology-wise, policy-wise, operationally, just making sure that personnel are where they should be in the best places for the effectiveness of our department. To your concern and to your point, I hear you loud and clear. I don't make any excuses for not making that process better on how we can brief you, but I do want to offer that opportunity on behalf of Colonel Davis and the department to see how we can close the gap and brief you and the commissioners and the chairman and this body on our progress. I do agree that we should have had some type of briefing at this point, and we can work on figuring out how we can do that moving forward.
I appreciate it. You know, my concern is, I know y'all are dealing with the DOJ suggestions, Bowman suggestion, all that's coming down. And it seems like a lot of this is, you know, the momentum's gaining to make the changes, and to which I think we all appreciate. But again, you know, and it may not be possible for you to answer right now, but certainly by next month, I'd like an idea, and I think everybody would, is a timeline.
Yes,
You
sir.
see what I'm saying? Because
Absolutely.
we've, you know, and I don't want to use the terminology, kick the can down the road, but kick the can down the road with these rule changes that several of us spent a lot of time working on. But if it's unnecessary, or it's overly redundant or repetitive with what's coming down, okay, great, then so be it. But we need some type of timeline, because I don't feel necessarily comfortable voting on this today, but also don't feel necessarily comfortable, you know, deferring it till later. If we don't know, if we don't have an idea of when that later date is, when we can really sit down and say, okay, this is all the information Office of State Police got in. This is what we're going to do. This is the changes we're making. So we can sit down, you know, all three parties and get through this.
And
So
look, what all,
timeline, do you have any idea?
yeah, I can't speak to a timeline, but I can get your answer. And I don't want to speak before Colonel Davis
Sure.
on that. But I can tell you, if I'm sitting in your seat, I understand the position that you're in. I would ask that too. I'm not going to tell you how to operate today, but I think it would give some time if we can have a briefing on where we are. That would give you better insight on the progress that we're making. I do stand before you and tell you, in the conversations that we had in particular to Chapter 16, there's still some discussions that we're having internally that we need to meet on as well, just to kind of get to a median or discuss a decision on what's viable here, what's duplicate, what's not needed. But you can't make that decision today. I agree with you, because we still have things that we're working on that may lean to the ultimate decision that's needed to be made on some of these rules that you're considering today.
I just want to join in Commissioner Rick's comments, as you know, and because you've been at some of these meetings, we have been working extremely hard
Yes, sir.
to try to accommodate all of the moving parts, to take comments from all of the interested parties. Obviously, the commission has to do what the commission believes is in the best interest, not of the commission, but of the agency and of the people that work for the agency, as well as for the people of Louisiana. But I like Heath, we don't want to do this in a vacuum, but we can't forever keep pushing this off. I would not oppose tabling most of Circular 228. Obviously, chapters 1 and chapter 12 are different issue. That's not what we're talking about here.
Yes, sir.
That deals with a very specific, minute issue that I think we can address today, that has to do with whether or not a written reprimand is discipline.
Right.
But for the rest of the circular, I would not be opposed to tabling it, but we've got to table it with a realistic timetable. So we need to hear back. I know you don't want to speak for the colonel, but we need to hear from the colonel before our next meeting as to what a reasonable timetable would be to, one, finish the process, because and so that the record will be clear, we understand, and you reached out to our executive director at a time that y'all were trying to formulate some of this and invited his participation. I don't know that that would be appropriate in the formulation process, because we don't want to run into a conflict of interest in helping with the formulation of y'all's rules and then have to rule on certain issues in the future.
Understood.
But we need to get to the point where y'all have gotten to some finality and can report to us where y'all are in that process, so that we can know what we need to do going forward.
Thank you, Mr. Chairman. And I do owe, I know we've spoken in our last correspondence. I am preparing some list of concerns or just issues that we raised in reference to Chapter 16, and I will present that in an email format to the Executive Director.
And that's fine. We always, as you know, we've had open discussions and we want to continue having those. But more important than just your expression of concerns about what we want to do is we need more information about what y'all have done and where y'all are, what changes have taken place, so that we can ensure that some of the unfortunate events that occurred are not as likely to occur in the future. And
Thank you.
I'm not speaking to the merits of anything in particular right now, but we can all, I think, agree there's been some unfortunate events in the past.
I can agree with you on that.
All right, so, and when, I don't want this to be taken as a comment on the merits of anything, but obviously we need some changes. And we need to know what changes y'all put in place, and we need a timeline from the colonel as to when we can sit down and get briefed on that as a commission.
Mr. Chairman, I assure you, you'll have that response before the next meeting.
So with that understanding, I would move that we table all of Circular 228 with the exception of that part of it that relates to the changes to Chapter 1 and Chapter 12.
And I'll second that.
I make a motion to amend your motion. Sure. And I'd also like to put chapter 2 with 1 and 12. I believe, chapter 2 has a timeline of December of 2022 or January of 2023. And I think we may benefit by voting on chapter 2 today as well, because it doesn't have or may not conflict with anything that state police is working on.
It may not. I personally would not accept that as a friendly amendment. Certainly if the commission wants to amend it. But because of the fact that there's only 5 of us here today, I'd prefer to wait until we have more people present than to add that to my amendment, my motion. But I mean, certainly you can make that, it's,
My motion is to add
substitute
chapter
motion.
2.
so there's been a motion and a second. There's also a motion for a substitute. Do we have a second to the substitute?
I'll second it for the purpose of discussion.
Been moved and second, so it's open for discussion. Right now, just to be clear, the motion is whether or not we will move forward on the change, move forward on a vote on the change to Chapter 2 today. Not whether we will change it or not change it.
The change that is suggested is just simply add the language beginning in 2023. The chairman and vice chairman shall be elected from the appointed membership at the first meeting held following December 31st of each year. So it's just a phrase that's added from its appointed membership.
Yeah, but with all fairness, that phrase basically says, in practical speaking, that the appointee by the troopers can never be the chairman. And that's something that was never a rule before, number one, but there's a history, recent and past history, long past history of the trooper designee being the chairman. Now, we can all agree that there might have been some perceived or real or whatever, however you want to phrase the conflicts of late with the trooper designee chairperson. But in the past, there was never an issue with this. So for me, I mean,
That's controversial.
that's controversial.
And that's the reason I would suggest that wait till we have more of our commissioners here rather than vote on it when there's only 5 commissioners here. But let's not get into the merits of it. Right now, the question is, do we want to hear it? And are we going to hear it now or are we going to hear it later?
I think we should hear it later when everybody's here and we've gotten through
Okay.
all of the later on. I mean, I want the other commissioners here. If we're going to make such drastic changes, we need to have a full house.
So call for a vote on the amendment to the.
So right now, we're voting on whether or not to accept the amendment to my motion. In other words, we're voting on whether we will consider the change to Chapter 2 today. All in favor would say, yes, we will consider it today. All in favor?
Yes.
Any opposed?
I'm
Yes.
opposed.
Yes.
The nays have
Nays.
it. We will not consider the changes to Chapter 2 today. Okay, now we'll vote on the other motion, which was to table everything in General Circular 228 with the exception of the proposed changes to Chapter 1 and 12. Any further discussion?
We had a motion in a second.
We had a motion and a second. Any other discussion? All in favor?
Aye.
Any opposed? The ayes have it. So now we move to the substantive discussion only of the changes to chapter 1 and chapter 12. I would move that we accept those proposed changes in the circular as published on chapters 1 and chapter 12. Do we have a second?
I would second it.
Have any further discussion? And obviously, if there's a discussion from the agency or from the Troopers Association, we would hear the discussion limited to those 2 chapters.
Mr. Chairman.
Now I want to amend my own motion. I want to amend it to make it clear that that we adopt the changes to chapter 1 and chapter 12 with an effective date after we, as a commission, approve them. So it won't have a retroactive, make it clear. I don't think it would legally have a retroactive effect, but just to make it clear that we're talking prospectively only would be my motion.
And as we're clarifying, just to another note, everything else is tabled besides 1 and 12.
Everything else is tabled
Circular
besides 1
220.
and 12, and any vote on the changes to 1 and 12 would be prospective only. Accept that in your second?
Absolutely.
Okay. Whoever seconded. Yes, sir. It would be appropriate time for comments from the Troopers Association, as we consider them a party to this particular discussion, yes. And if the agency wants to comment on it.
On 1 and 12.
On 1 and 12.
And I'll make it very brief since we're limiting the vote to just chapters 1 and 12. But I do want to take the opportunity to thank you and thank the executive director, Ms. Feeney, for inviting us into the conversation and having the Troopers Association representative. Obviously, we're not there on chapters 2 and some of the other chapter.
We're just talking 1 and 12 today.
But on 1 and 12, we would support from the Troopers Association the changes that have been recommended. So thank you.
Well, thank you. And you reserve your right to object to other stuff later.
Yes, sir.
Yes, sir. Anything from the agency?
No, for the record, we'll just stand in concurrence with just stated. We also support those changes that are being considered today, except the discussion for the other ones.
As we've had many discussions in the past.
Thank you, sir.
All right, thank you. Any discussion from any commissioners? All in favor, say aye.
Aye.
Any opposed? Ayes have it. So the rules changes to chapters 1 and 12 as promulgated in the General Circular 228 have been approved and will go into effect immediately. The other matters have been tabled for discussion at a later date with the understanding that the agency will get with us as to a proposed timetable in the very near future. So when we can get a full briefing.
Yes, sir.
Thank you. Takes us to the director's report.
Yes. Yes, Mr. Chairman, I have 6 items on the report, but I should be brief. The first thing behind tab number 8 in your binders is the final budget closeout for fiscal year 21, 22. And as you can see, we finished last year with just under 1.5% of our appropriation once everything was tallied. So, yeah, it was right there at the very end there. We finished out very close to our full appropriation. The next item, do you have any questions regarding that? The second report behind tab 8 is the current expenditure report. Again, that just shows where we are currently with our current appropriation and expenditures to date. Any question about the commission's expenditures?
Would be through the date that.
The date is it'd be October 11th.
October 11th.
The next item on the next chart you'll find in your packet would actually be about the proposed budget request for fiscal year 23-24. I'm proposing that this essentially be at continuation budget levels. The request is due by November 1st. As of now, as it laid out in this chart, it would consist of standard inflationary and annual performance adjustment requests, as well as a nominal increase to travel, operating services, and supplies. The total request would be approximately 4% above our current level, or without the inflationary adjustments, which are rarely granted, about 3.75% over our current operating budget. We want to look at subscriptions for like Microsoft 365, additional licenses for Adobe. If you look back at I think we spent all but $35 in supplies last year, and we have a new employee. And so some of those things, those operational expenses, we want to make sure are funded properly in next year's budget. Want to make sure you're aware of these priorities. I will be sending out a more finalized version for you to review. And I don't know if you had any questions about proceeding with this request. Again, I'll circulate the final budget proposal request for your review before the official submission deadline.
Do we need to approve that? I guess that's helpful.
It doesn't require a vote, but if
All right, we'll entertain a motion to approve the request.
I would so move.
Second.
All in favor?
Aye.
You now have our formal
Oh,
approval.
a formal to proceed. All right, well, I'll proceed accordingly. Next would be the promotional exam. I just want to make you aware that we have the optional promotional exam set for November 21st. And the deadline for eligible classified employees to apply is October 24th. To date, we have 170 troopers registered to take the promotional exam in November. So it's like successful. The annual training requirements, the annual ethics and preventing sexual harassment training courses must be completed by the end of the calendar year, and we will begin circulating that training information and reminders to each of you. And then we are reviewing options for our November meeting. It's currently set for November 10th at 9 a.m. However, I think we might need to work around the scheduling conflicts, and I'll be in touch with each of you on that. And that concludes my director's report.
Any questions for the director? Next is the opportunity to address commission by employees or others on matters not on the agenda. Did we receive any requests?
We did not, Mr. Chairman.
So we'll entertain a motion to adjourn.
So moved.
Any opposition? Oppositions, we are adjourned.